Hello, and welcome to Know Your Rights, a short video series from Nevada Legal Services. Today, I'm going to talk about what constitutes misconduct for denial of unemployment benefits in Nevada. My name is Rhea Gertken, and I'm an attorney with the Reno office of Nevada Legal Services. Nevada Revised Statutes, Chapter 612, covers unemployment benefit eligibility, payment of benefits, and appeals of unemployment benefit ineligibility in Nevada. All of these links are available in the description box below. This video will explore one way a claim for unemployment benefits can be denied. Generally, unemployment benefits are paid to workers who are unemployed through no fault of their own. Therefore, it is possible you could be denied unemployment benefits for a variety of reasons. The reason we are going to address in this video is whether an employee was terminated from his or her employment due to misconduct. NRS 612.385 is the statutory basis for denials due to misconduct in connection with the employment. In order to show misconduct, the employer must show that the employee engaged in a deliberate violation or disregard of standards of behavior which the employer has the right to expect, or that the employee is careless or negligent to such a degree that it shows a substantial disregard of the employer's interest or the employee's duties or obligations to the employer. However, ordinary negligence in isolated instances or good faith errors in judgment or discretion are not misconduct. Moreover, there must be an element of wrongfulness in the employee's conduct to rise to the level of disqualifying misconduct. Simply not being able to perform job duties is not misconduct if the employee is making an effort and there is no deliberate violation of standards of behavior or wrongfulness in the employee's conduct. Other examples where the conduct was not wrongful include simply counting accidents in the case of drivers, refusing to work different hours, or refusing to work a less favorable station. Generally, we see terminations for misconduct where the employee has violated company policy. It is extremely important that every employee be aware of the company policies and make sure you have a copy of the policy or personnel manual. But not every violation of company policy is sufficient to warrant a finding of misconduct. Remember the standard. The employee must deliberately and unjustifiably violate or disregard reasonable policies or standards of behavior. The employer has the burden to show the employee committed disqualifying misconduct, and that conduct must include an element of wrongfulness. Once the employer makes the initial showing, though, the employee has the ability to provide a justification for the actions and can show he or she did not engage in disqualifying misconduct. The employee must show that the conduct at issue was reasonable and justified under the circumstances. But, if found ineligible due to misconduct, you generally must earn more than your weekly benefit amount for 15 weeks to establish a new period of eligibility. Some examples of misconduct include not calling in before missing or being late for work, known as a no-call, no-show, leaving property or goods unattended, failing to maintain required certifications, and incarceration due to criminal activity, even criminal activity that was not connected to the employment, because the incarceration itself can be found to have been misconduct. Again, though, these situations could be rebutted if the employee had a reasonable justification for the actions. Finally, one example that is not misconduct, incarceration due to an inability to post bond, has been found not to be misconduct. This concludes this video and discussion of misconduct in Nevada. For more information about your rights, or if you have received a denial notice, you may contact any of our local offices or visit our website at nlslaw.net.